5, 4, 3, 2, 1. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observations: public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Orders are not like old wine, becoming better as they grow older. This court, after considering the aforesaid proposition of law, is of the view that since that there is no reference of any show cause notice in the order impugned, and as such there is no requirement to grant adjournment to the writ petitioner to file counter affidavit, taking into consideration the law as settled by Honorable Apex Court in the case of Mohinder Singh Gill Supra, due to the simple reason that even if the state will come out with the stand in the counter affidavit that the notice has been given, but since it is not being reflected in the impugned order, therefore the same will be nothing but will amount to allowing the respondent to improve the finding recorded in the impugned order by making reference of the same in the counter affidavit. The position of law is well settled that the justifiability of the impugned order or the observance of the principle of natural justice is to be reflected from the face of the record. This court, after considering the aforesaid position of law, is of the view that since on the face of the impugned order dated 5/12/2021, although the reference of inquiry is there, but there is no reference of any inquiry as to whether before taking such decision to dispense with the service of the writ petitioner any show cause notice has been issued. As such, the said order, according to the considered view of this court, is not sustainable due to want of the principle of natural justice. Accordingly, the impugned order dated 5/12/2021 is hereby quashed and set aside. In consequence thereof, the matter is remitted before the authority concerned to take decision afresh after giving a notice to the writ petitioner within the stipulated period of 4 weeks from the date of receipt of copy of the order. If such notice will be given to the writ petitioner, the same must be responded by the writ petitioner within the further period of 3 weeks from the date of receipt of the said notice. The concerned competent authority will take decision on its own merit after 3 weeks from the date of response of the said notice. The further continuation of the writ petitioner in service will depend upon the final outcome of the decision to be taken by the respondent as directed above. Accordingly, the writ petition stands disposed of. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.